Now comes a difficult chore, which is to speak after lunch. But luckily, we're in luck here because we have two people that need no introduction and will make it what I'm confident is to be a very entertaining conversation. Again, in previous years, we've had a keynote address, but this year, again, with the concept that, MIAS, we try to make everything interactive, we decided instead of having a single keynote address, have two prominent members come out and have a conversation about the issues at hand. And as I mentioned, neither of these individuals need an introduction, but we'll give them an introduction anyway. On the far left is Fernando Mantilla-Serrano, who chairs Latham and Watkins. He's a global chair for international arbitration. He, again, is renowned. He's, represents companies, states, state-owned entities, in any field, oil and gas, energy, construction. He is on the ICA governing board. He's on the SIAC, Singapore International Arbitration Center governing board. I guess we could go back to his days at the ICC, but at some point even his mother will be embarrassed by how many things we say about him. Similarly, we have one of the world's most renowned arbitrators, Guido Tawil, at his arbitrator chambers. He was formerly associated with the Mullins firm out of Argentina. He's a professor of administrative law. He has been very involved in the IBA. He oversaw the IBA rules of evidence being revised, as well as the guidelines on conflicts. He has published 7 books. And again, he's been an arbitrator in a innumerable number of cases. So with that, I will turn it over to Fernando and Guido.
Well, thanks very much, Luis, for the invitation. A pleasure to be here, particularly to chat with Fernando, whom we know each other for 30 years. And
close to 30 years.
I always tell my first case as a counsel, he was the ICC counsel at that case. So
we have been in almost every single position. Me, counsel, the
opposite counsel.
Exactly, and we have been co-arbitrators. You chaired co-arbitrator, vice versa. So yeah, we know each other well. So that's the reason we can discuss being opposite to each other and still remain friends.
Yeah, many years, and it's a pleasure. It's a pleasure to be here. Thanks again for the invitation. First issue, we're going to just fire chat, throw subjects and sort some views. First issue, Fernando, current status of international arbitration. How do you see international arbitration, particularly investment arbitration?
Yeah, I think that's probably, I would say that today, and let's focus on investment arbitration, forget a little bit about commercial arbitration. I think that the main characteristics today of what I would probably say would command the trends in investment arbitration is a general backlash by states. I think it is clear that now in the treaties of fifth generation, with the mechanism of appeal, with the curtailing of the protections and the joint interpretation declarations by the states, it is all aimed at circumscribe the protection and reflects a certain kind of, I would say, fear of the states on the basis of what they have realized has become quite an effective means for prosecuting and going after alleged violation of treaty protection. So that's for me the first one. The second one, and I'm not saying whether it is positive or negative. I am trying to be objective. The second one, I think, is the amount of newcomers. I think that, and then compared to commercial arbitration, I think that investment arbitration has been more prone to open the doors for newcomers, both as arbitrators and as counsel. And I think the third point, and this now I put my hat of counsel in a big law firm, what I would call the dumping of legal services. I think that investment arbitration nowadays, you have, and I use the right word, dumping of services, because as soon as any law firm wish to have a name in international arbitration, they take the path of investment arbitration. It is relatively simple to develop minimum expertise in investment arbitration and then to compete with prices. And that we have seen it, and is more and more difficult for firms like mine today to represent states in investment arbitration, because one, the procurement restrictions by states, and second, the firms that are able and willing to do these arbitrations for peanuts is enormous. So I think that that's probably the three trends that I will mention. What do you think about this, Guido?
I'm a little bit. I would say first thing is there's a backlash, but I think that's the price of success. I mean, if investment arbitration would have not succeeded, if you didn't have the cases, you would not have the backlash. Remember when the whole investment arbitration system started, it was theoretical. I remember speaking with Antonio Parra at that time, who was the Secretary General of ICSID, saying, we have 6 cases already. We don't want more cases. No, the opposite. You want to develop the system. The system works. That's why you have so many cases. The problem is you need to be able to cope with the cases and realize that in some cases you're going to win and others you're going to lose. If a respondent has not acted correctly, he's going to lose. Some countries, as Mexico, historically, has accepted the system. And they say, I remember Hugo Perezcano and others saying, well, the system works, and that's how you need to deal. I think that the same situation that we had for many years with developing countries being criticized for the Calvo clauses and soft Calvo, etc., has probably happened some years ago with developed countries being sued. And I think that the system has not been defended by those that should have defended the system. And remember what was to a certain extent, the criteria, the rationale behind the ICSID Convention. The ICSID Convention wanted to have it both sides, to have the developed countries having their investors being protected, and the developing countries having the system stopping any sort of retaliatory measures. So at the end, the problem is, if the backlash gets to a moment where the system no longer exists, the system's going to get a way out. I mean, investments will be done even if the exit system or if the investment settlement dispute system is not available. Some way they're gonna find a way out.
Yeah, it's funny because you think that the backlash is the reflection of success. I have a different theory. I think that the backlash is the reflection of the states realizing what they were entering into when they signed BITs. I think that at the beginning, when the BITs of first generation, they were used like as just, okay, it is nice. I mean, there is
a marketing issue.
More than that, it was, okay, listen, this is a state visit. I mean, we are going to receive the president of France. We have to sign agreements. Let's sign a BIT. I mean, what does it make to sign a BIT? I mean, it's just a couple of articles, general kind of protections. And I believe that the states didn't realize that this was going to have teeth, and that they could be really sued on this basis.
They thought it was a theoretical situation.
And when this started, the problem when they realized and 2 things. First, that this was going to become a public affair. I mean, this is public. The media was going to intervene. Everyone was going to be aware of what was going on these arbitrations. And second, to the extent that the states were the one granting the protection, by definition, the states were respondents. And it's not nice to be a respondent. And I think that the states realized that they were signing treaties that would necessarily make them respondents by definition. And I think that that's what is happening now. I mean, they said, okay, listen, we just open kind of a Pandora box, and now we have to limit it. And I think that that's really the reason.
In any case, I'm of the opinion, I have always been of the opinion that investment disputes need, if possible, not to be part of a legal discussion. Many of the investment disputes should be settled before getting to arbitration. I understand there are limitations for public officials to settle disputes, but the truth is that a system where the investor gets back his money and get out of the country where he has invested, or while the country stays with the money and the investor is gone, is nothing to be happy for any of the parties. What you need is investment to multiply, to stay in the country and to develop. So I think there's, and many countries initially worked in a different way. They worked more on a diplomatic level. I think that when they go to lawyers, and I say this against ourselves, it ends in disputes that in many cases could be avoided. I mean, it's an issue that I think it needs to be second thought on how to keep the investment there. Of course, you have cases where there's someone that's probably too quick or too opportunistic. But the truth is that in many cases there should be way out for the investment to multiply.
Yeah, but Guido, and this applies to every single country I have been involved with. Who is going to be the functionary, the employee, the public officer that is going to sign a settlement?
I agree.
I mean, and this is both applies to developed and undeveloped countries. I mean, and the most high is the public officer, the riskier that it become for him politically, and actually, I mean, for his own integrity, having the and here in Latin America, in general terms, we know Fiscalia, Contraloria after him because signing these agreements.
That is why mediation in investment arbitration does not work.
And at one point, I mean, we were talking about corruption this morning. In every single settlement in which an state or an state control entity is involved, there is always a suspicion of corruption. Why did settle this matter without fighting all the way until all appeals possible? Probably there was corruption. So immediately a settlement involving a state or a state-owned company has a sort of a red flag, which is completely unfair, of course, but that's the way it is.
I agree. Second topic that we have selected, the issue of what should arbitrators do in this sort of debate of should arbitrators develop law in their decisions or should solve the particular dispute? I'm one of those that thinks that you should be solving the dispute and that's it. I mean, if you want to create law or if you want to sort of put forward new grounds or new paths, you can do that in writing. You can author an article, a book, or whatever. I don't think that's the place to do it. Not in the world. I think that we're called only to decide the case. Of course, sometimes you are going to be entering in new terrains. That's inevitable. But I don't think you need to seek that. And in many cases, it happens to us as arbitrators. You start telling some of your colleagues, this is not the place to do this.
Listen, I think for those who know me, I am very critical of the publicity of awards. And I think that that's one of the risks. And why I say so? First, because I agree, I don't believe that, and I stress again, talking about investment arbitration, I don't believe that the job of an arbitrator is to create, modify, enhance investment law. I mean, if that's the result of the decision, so be it. But it's not the aim. And I think that that's the first point. I mean, the aim, and I agree 100% with Guido, is to resolve the dispute between the parties. But second, and this comes to my point on publicity and publication of awards, the problem with this publicity that surrounds investment arbitration is that there is a tendency by arbitrators to write thinking of the public that is going to read the award. So they are not writing for the parties first. They are writing for themselves, their perception, and how public is going to read this award. is, if I say so, if this is the approach I'm taking, will I be tagged as pro-investor, pro-state? I have to be very careful. And probably some people, and we all know names, will make kind of a point of presenting themselves. Listen, I am so good as pro-investor that, listen, I prepared this dissenting opinion, and that goes to the dissenting opinion, because it's the way to do my own publicity. And same situation for those who want to hold the shop like being, okay, I'm pro-state. So I think that that's one of the problems that we have with investment arbitration. And not to mention the length of the awards. And then I think that the awards are becoming lengthy and lengthier, and citing completely useless citations just to add, to reassure themselves, listen, has been 30 tribunals deciding this way, so they should be right. And that's, for me, is not the right approach for the decision of the dispute among the parties.
You touch upon the issue of dissenting opinions. So your view is, should you be able to write a dissenting opinion? Are you against? I mean, there's a famous debate, an article of Arbitration many years ago.
Yes. I mean, I wouldn't take a sort of manichaeist approach, good or bad. I give you my example. I think that in my entire life, I have written no more than 4 dissenting opinions. And I only write a dissenting opinion when I consider that the majority has reached a conclusion that, for me, I cannot really espouse because it's outrageous in the result. If we are discussing about different interpretation of the contract, different interpretation of law, different appreciation of evidence, I would never write a dissenting opinion. I think that that's part of the deliberation. I mean, you are put in a minority. Okay, I mean, that's the situation. I think you don't need to voice that kind of disagreement. For me, the dissenting opinion is something that reflects how outrageous the decision of the majority is for your own possibility to espouse or sign the word.
I think dissenting opinion is a matter of conscience. You need to feel comfortable. If you don't feel comfortable, if you think that you should do it, I think I see no problem. Probably in my culture is something that you should be able to do. I write dissenting opinions when I don't agree. In any case, I believe that dissenting opinions should be short, to the point, and gentle. I totally disagree with those burning dissenting opinions of hundreds of pages or aggressive, or I don't think that's a style. I think you should be to the point and short, but I think that when you are not comfortable in particular, not only the solution of the case, but in what is said for future cases, you should be able to point it out. Because if not, it's very difficult to understand the reasoning of the tribunal. And I understand some arbitrators, as Albert Jan said, well, that to a certain extent affects the award for the future, for annulment proceedings or whatever. But I think that your first duty is with your conscience. And if you don't feel comfortable, you should voice it out gently and to the point.
But you mentioned something, Guido, that it was important for future decisions. So now, I mean, you were telling me before that you were writing decisions for the parties, but on the back of your mind, you are thinking of the future decisions.
On the future decisions concerning what somebody could think, I think of. I'm thinking about
making law.
Yeah, nor how am I going to be put in history. I'm not thinking about that. What I'm thinking is somebody needs to understand how I think. In many cases, I had big discussions in deliberations, saying, I mean, we are all in agreement in going this way, but you cannot go through this loop because I just cannot support that. I can say this. There was a discussion we had in a deliberation many years ago. If a holding corporation could be considered an investor or not, and we disagreed on that. We finally were able to avoid the issue. But even if we would agree on the same result, there are things that sometimes you cannot accept. And that's part of the to a certain extent, the discussion among the tribunal, no? how to reach the solution. In many cases, you are in agreement and the final solution, but how to reach on that. And I think it's relevant. It's not only the solution, it's how you reach the solution.
Yeah, but again, I mean, what I see is all that will depend enormously on the facts, on the way the arguments have been presented, on the wording of the treaty. So I do not believe that, to follow your example, let's imagine something like the definition of investment. Is this an investment or is not an investment? I mean, I may have a clear idea of what the investment is, and if this concrete investment qualifies or not as a protected investment. I mean, if I am put in a minority, do you think that you help the parties, again, because you write the dissenting opinion?
No, I'm not thinking about the parties. I'm thinking about my conscience. What I'm saying is, if you are deciding on the facts, it's much more easy. The problem is when you go out of the facts and you start sort of setting principles. And that's where you have sometimes difficulties.
I will go back to your answer. I would say I will not write a dissenting opinion, but I will write an article in a revue de l'arbitrage or Arbitration International.
What do you think can be made in order to control costs and time in arbitration? Is there anything that could be made?
Well, I was tempted to say, listen, let's fire all lawyers in the arbitration.
Sorry?
Admission against interest. No, listen, seriously speaking, I think that we should try to avoid, and when I say we, I talk both about counsel and arbitrators, to mimic. Because I think that part of the problem today in arbitration is that we are forgetting about the flexibility that made arbitration initially so attractive. And I give you the example, procedural order number 1. I bet that everyone around this room, you have a model procedural order number 1 somewhere in your computer. And you take that model and you replicate it. And you create phases that probably none had thought of, but now that you put it, the parties say, listen, yes, why not? And it happened that way with, for instance, the exhibition, the production of documents phase. Now it's in the standard phase. It is always necessary. So I think that that's where probably we should all make an effort to go back to the basics and try to say, listen, let's design a procedure that is adapted to the kind of dispute, to the precise parties, to the counsel we are dealing with in this specific arbitration, instead of having already pre-written procedural orders. And this applies also to institutions, because sometimes institutions suggest these pre-written models. And I think that probably is one of the sources. I wouldn't say that the only one, but one of the sources of the increase on time and cost.
In my view, the first thing one should think when how to reduce costs in arbitration is international investment dispute is not something cheap. It's not something that you could. Not every dispute should be taken into arbitration. There are a lot of disputes that should not be taken into arbitration if you think that you have a limitation on a budget. There's a lot of things that could be done. I think that in many cases, as an example, one sees too many expert reports. That's something that happens. In some cases, I must say, we have excellent experts. In other cases, I just cannot justify experts collecting more than counsel. I have cases where the fees of the experts overpass the fees of the counsel in the arbitration. And of course, fees is relevant. And cases are. I mean, we had cases. I don't know if in your experience, I had cases where the cost of the arbitration were one firm over 30 million in one case, 40 million.
It was not Latham Watkins.
But the truth is that in the first thing is what's the size of your dispute?
Yeah, but I go back to the mimics. I mean, because I'm talking about expert witnesses, I have found myself in a situation in which I thought at the beginning I didn't need that many witnesses. I didn't need probably even that many experts. But when you are mostly when you are in defense, and you see that the submission arrives with 2-3 expert reports and 4 or 5 witnesses, I think I prefer to lose the case with 3 experts and 5 witnesses than no experts and no witnesses. And so, I mean, I'm not saying that it's correct, my analysis, but I think that that's exactly the kind of reaction that we should try to overcome. Because actually, the first to shoot is the one that is kind of calling the tune for the dance. And then it is kind of a never-ending run of adding cost, resources, and exhausting and leaving no stone unturned. And I think that that's really what is increasing the cost of arbitration. And at one point, I think that fear of probably incurring in liability or even in bad perception towards the client is something that we should fight for. I'm talking aloud, talking to myself, because I recognize that even myself sometimes falls into this trap.
What about the future of arbitration? How do you think it's going to evolve? Where are we going to be in 10 years? I mean, not ourselves, but where is arbitration going to be in 10 years' time or 20 years' time?
Well, again, talking about investment arbitration, I think that probably, I mean, it's difficult because I don't want to be pessimistic, but I think that the glorious days of investment arbitration are gone. I think that the system is about to suffer a big transformation, and this coming essentially from the States. Probably, and you have seen the new analysis that have been carried out by the ICC and I think it's UNIDROIT, talking again to investment contracts, and it's funny because when this work group was created at the ICC Institute, it was announced like a sort of a revolution. But if we look into history, the protection of investment started with investment contracts. I mean, at the beginning, before the big kind of flavor of the day situation that BITs created in the 80s, 90s, the protection of investment was made through investment contracts. And actually, in Africa, still, you have mostly investment contracts, no BITs. So probably what we have done now is coming back to the sources. And probably the era of this kind of open BIT protection for investments is over. And probably investors, the first, I'm not saying that it's only the States, I think investors are questioning themselves whether this system is really working for them either. And probably they are the first that are going to be more interested in having investment contracts than just trusting or relying on the umbrella protection of an investment treaty.
Oh, yeah, I agree. I think that we will probably be seeing much more contract-based settlement disputes in investment arbitration. I think we should, although it's in its preliminary stages, we should see the work of UNIDROIT and the ICC Institute more closely. I think effectively that's going to be more relevant. It's already happening in some of the cases, as an example, Argentina and Terrigi and other new systems. They're getting much more into that system. So I fully agree. I don't know what's going to happen with arbitration in general, in the sense of how technology is going to impact our system, artificial intelligence. More and more, one is starting to inquire the parties, how are they going to be using artificial intelligence? How are they seeing the system working with this new technologies? It's totally uncertain for all of us, no? But that's something that's going to happen, and it's going to be relevant. It's clear. I want to see how that impacts on the play field of arbitration, no?
I mean, I am optimistic by nature, so I think that this is going to be good for everyone. I think that it's like when the internet came, when the computers appeared. I mean, at the beginning, there is a challenge. At the beginning, you need to adapt. But at the end, it's going to be positive. Of course, I mean, there will be risks, but I am sure that we will be able to develop the safeguards to avoid risks and abuses. We were discussing at the table before about the kind of different capacity of parties to be represented by counsel that would be able to rely more or less in artificial intelligence. I think that that's the fact of life. I mean, sometimes some parties have better resources than the others. I don't believe that is the job of an arbitral tribunal or of an institution to try to put all the parties at the same level. I mean, we are not at the same level in life. I don't believe that it's going to be different in arbitration, but it has not been different in the past, in the present, and it will not be different in the future.
What is true is that technology has a big impact in our legal profession, and particularly this takes us probably to the final topic in this initial approach is what should we advise youngsters to do? No? How should they approach the arbitration world? How this impact? As an example, we were speaking about the pandemic, and it's truth. We discussed with some of our colleagues that remote hearings was very effective for some purposes. It reduced costs. It make, of course, things and people go more to the point. But the truth is that there's some unwitting victims of all this situation, and those are sometimes youngsters. Young associates with a remote system have less opportunities of learning than with the interaction with arbitrator and counsel. No? And this, again, with all these technologies, what should one advise youngsters to do? And we were discussing before, we discussed yesterday night as well, is you see different signals for youngsters in how to get into arbitration. There's a lot of people that think of international arbitration as something sexy, that you fly in first class and you eat oysters all day, no? And that's a bit. Of course, it's a great field, and it's something very interesting because of different cultures. But one needs to know where you settle, what are the real possibilities. All of us have had many people trying to get into the field, sending CVs and saying, I want to do a practice with you. And we were discussing yesterday a typical case of French firms where you have someone being an étagère for 6 months in one firm, moving to another one, and 3 or 4 years after, still circling around different firms. And there's an issue, people need to know their market. We also discuss the issue of course, moot courts are wonderful as a life experience for the people to encounter colleagues of other cultures. But that should not give you the wrong impression of what's the real market. I was some years ago very pessimistic about how to construct your career in international arbitration, and I think we agree on this. You need to first look how to go deeper into law, into material law, commercial law, international law, administrative law, and then get into arbitration. But if you think that you are going to make a career in international arbitration just because you do a master's degree or program in arbitration, that's wrong. And that's something that there's a certain conflict of interest that all of us need to dissipate when we advise youngsters. Is first look for a major in sort of the main topics of law, and then try to join a team of you're going to learn arbitration working in arbitration. That's the way you learn arbitration. It's very difficult that because you make a a graduate course, you're going to know arbitration, probably going to know the theoretical part of arbitration, probably more than most of us. But that's not the way you're going to build your career in arbitration. And that's something that needs to be said. And I don't think that it's said so strongly as it should be.
Yeah, I think that probably, and this is something that everyone should think about. I mean, institutions, academic institutions, about whether probably we are not selling kind of illusions. It is true that we are very lucky in the world of international arbitration, not because the first class and cocktails, etc., but because we probably do not realize, but we deal in a very sophisticated group of people. I mean, when I see my partners that do exclusively M&A, that do tax, that do finance, I mean, it's always dealing with the same kind of people from the same horizon, very local. Even if they do international transactions, the group that is in Paris just deal with the Paris aspect of the transaction, the ones in New York with the New York aspect of the transaction. I mean, we are very lucky, so that's no doubt about it. But I fully agree with Guido that what is important, and I wearing the hat of the recruiter, I look for the solid legal acumen basis of the candidate. I don't need that he tells me that he knows the ICC rules, the Washington Convention by heart. I mean, everyone can do that. I mean, the ICC rules, 45 articles, whatever. I mean, one night and you read them. So there is not a big issue there. She contract law, obligations, I mean, that I don't have the time to teach him or her about that. Better she masters the basics. I will have more than time enough to teach them about how to apply this or that article of the ICC rules of the Exit Convention. But the law, the substantive law, the criteria to analyze a legal provision, that's what I am looking for in a candidate. And I think that universities and institutions should be keen. I wouldn't say that programs for international arbitration are not useful, they're very useful, but I think that it's important to convey to the students two things. First, that this is a procedure and not substantive law, and that what is important is the substantive law. And second, that there is not a huge and enormous market for everyone. Because that's the other point. I mean, when I started doing arbitration, there were no programs about international arbitration. Now, almost every single university has a program on international arbitration. Good, excellent. Now, be careful not to sell false illusions.
Luis, do you have any... We discussed the possibility of receiving questions from the public.
Yes, I ask everyone if anyone has a question, just raise their hand or put it on the app. No one has, they've been listening to you. Gilbert.
Good afternoon, and thanks for the wonderful conversation. And it was really immersive. I did a silver spiders, and I'm based in my area, Florida. I kind of queried last time that I wasn't sure that one of you said that there was no one from mediation even as their state matter. That I think I heard that, and I wondered whether we can just expand on that a little.
Yeah, it was me. And it's not that there's no room, but it's not a matter of how good is the mediation rules or system. The problem with mediation is if you don't give a backing on the one mediating, in the sense of the one taking the decision in the government, it's impossible. I mean, you can have the greatest mediation rules, but if the official that needs to settle thinks that he's going to incur into political responsibility or bring criminal pursuit afterwards, he will never settle. And that's why in many cases, the officials just wait for someone to order them to pay or whatever. And it's a pity, because many cases should be settled.
First, Silvia.
Related to the question and the answer, then at the risk of sounding very pragmatic, which may be a stage in this context, but instead of trying to figure out other esoteric reforms that can be implemented, wouldn't it be helpful for states to develop a protocol, a system, a way for those mediations and settlements to happen, as opposed to start thinking of how to regulate BCUF and the other?
No, I fully agree, and I think that's a way out. The problem there is in countries where there's mature relationship in politics. That's possible. You could have a bipartisan committee to sort of address a matter and settle disputes. That would be great. But sometimes that political relationship does not work that way. So somebody's trying to take an opportunistic approach. But I think certainly the way of settlement of disputes and how countries address us in their internal systems is one of the key issues that can solve a lot of the disputes.
Kathleen?
So we saw the ICC when we talked in depth with commercial.
Yeah, it works, but I just don't hear what.
Well, we saw the ICC when we talked in depth with commercial and House Counsel for like 45 sessions about how one can go and mediate. And I understand that Justice is different explain, which, what we learned was that at the moment the claims filed, it's often that's too late to pay it for you. So one with different mechanisms. That had to be more true though. So I agree with the something 100% that when you can use how to search them, it allows before just speech and fraud, to be factoring more than what's happening. That is related to the fact that law firms now are filing shoots much more quickly. So there isn't a time for that kind of analysis to happen. And for the last couple of years, you're putting that word distinction stuff was, what we see in law firms is people go straight into litigation or they go straight into arbitration out of law state, which, they don't have substantive expertise often. Which in what it takes for terrible leaders to restructure they had to do both. And we saw that the quality of the solicitor that had done both, I don't go with the quality goes for associates. He's different in those cases because they had really done the comments. So I want us to say that kind of law firms as well after they hired the people, not just looking straight into the state.
Listen, coming back to the mediation point, because I know Sylvia was challenging me, I heard that. Mm-hmm. So the point here, I don't want to be pessimistic, but the issue, and that kind of impregnates the whole system of investment arbitration, has a name, is politics. And investment arbitration by definition involves politics. And then I think that the equation changes completely from a commercial approach. In a commercial approach, and I have been involved in mediation in commercial arbitration, and they have worked, and I fully support. I'm not a mediator. I think that you need to be a real qualified mediator. I'm not, but I have used mediators, and I have mediated difficult cases, never in investment arbitration. And not because you have an investor that is completely unreasonable or an estate that doesn't want to settle. It's because there is the political component. And that political component do not respond to business analysis. And therefore, that's the reason why I consider that mediation, I would love that it has a future in investment arbitration, but I don't believe it's realistic to present that an state, a government, because the state is eternal, governments change, that a government will have the political capital to take that road of a mediation. I mean, that I think that is a major obstacle, and I don't have the answer how to solve it, because I think that's inherent to the investment dispute mechanism and the investment dispute arena.
Going back to the issue, I think that how the the dispute is settled. It's more of an issue of domestic law, no, more than international. Well, but the truth is that countries could be talking and how to develop domestic systems that have some sort of similarities or way out. I think that's an effort that should be addressed. And that's, if we can tell that to the countries, I think we have here Mr. Larrea, Attorney General of Ecuador, and others. I think that's something it's quite interesting, at least from the perspective of arbitrators. That's an issue that should be addressed.
Back there? Okay.
Yeah, I was the director for international investment disputes for the Republic of Costa Rica. And let me tell you that the policy that Costa Rica had at that point was to try to prevent and settle most of the disputes before they even get into arbitration. And I don't really think that's necessarily the case in most of the countries, but we even had we were watching the papers just to make sure that something that an officer was saying in public could create a possible threat of a dispute case for Costa Rica. Let me tell you, Costa Rica has been very successful. They have won most of their cases, but there are many cases that were even settled before they even got public. Now, there's a moment when the issue gets so public, because it does get into the papers and you're already starting an arbitration, when it does become very difficult to settle, and you probably require an arbitration decision to be able to go to the outcome of that dispute. But other than that, I think it's more a matter of internal policy and on how the government sends seeing potential threats on investment. In many cases, I remember we saw cases where we thought there was a potential threat for an investment arbitration, and probably the government was not doing right. And of course, sometimes even in other branches of the government, like the judiciary or municipalities, and we had to go and had meetings and try to see how to settle before that became a threat. So it's more a matter of how each country handles its policy on for investment disputes.
I'm just going to take the power of the mic. One last question. You were both kind of negative in the future for your investment arbitration. It's going to be difficult. I was wondering, this whole concept of standing investment courts, is this just going to be transferred over to that? Is that really a solution? What are your thoughts on that concept of having standing investment courts?
I don't like standing investment courts. I think that's not arbitration. That's permanent courts. And I mean, if permanent courts work, I don't think any of us would be doing arbitration. We're going to be litigating before the judiciary if that's the system. So if standing courts finally are applied, I think that's what's going to happen is we're going to go back to contract-based system, alternative systems. But I don't think we're not going to have investment arbitration as we know. We have, probably not as we know. We're going to have investment arbitration. It's probably going to be different. But I don't think the solution is investment courts as they are discussed right now.
Yeah, I mean, it raises many issues. I mean, who's going to appoint the judges? How the investor is going to feel that he's represented in that kind of permanent court? But I will end with something that is probably a little bit more philosophical and applies both to commercial and investment arbitration. The whole thing of arbitration started because we wanted some kind of an alternative to the judiciary. We wanted flexibility. We wanted the possibility to choose arbitrators. And every time we kind of start adding layers and layers, now we want something that gives us the possibility to have recourses. We want the possibility to have probably an appellate court. We want the possibility to have standing judges. So I think that we are now going back to the point zero. So let's go back to the courts. No, that's not arbitration, and we are basically trying to have an arbitration that resembles state court proceedings, and I think that's wrong. And that's philosophically, I think that we are getting something wrong. We either have arbitration with the pros and cons, I'm not saying that it's a perfect system, or we have a state court system. But when we start mixing the two of them and trying to make cherry picking, I think that we are going to have a sort of Frankenstein that will be a disaster for resolution of disputes at the international level.
Okay. Well, let's thank both Guido and Fernando. So,